In the matter of Operation ASHA versus SHELLY, Supreme Court dismissed the appeal and said that underlying suit filed before single judge of High Court must be commenced at earliest, and High Court must pay careful attention to whether circumstances necessitating imposition of a constructive trust is made out. If yes, it must delineate properties which would be subjected to constructive trust and assess whether the reliefs played for. Operation ASHA is not-for-profit society founded in year 2005 and registered under Societies Registration Act 1860 with registered office in New Delhi. Appellant Society is engaged in providing health services through plethora of activities to underprivileged sections of society across India with special emphasis on treatment, education and prevention of tuberculosis and other diseases. The same can be inferred from Memorandum of Association of Appellant Society. The MOA of the Appellant Society also stipulates that all incomes and earnings of society, whether movable or immovable, shall solely be utilized to further aims and objectives of appellant society. Furthermore, it is stated that members of appellant society would not be entitled to any profits by virtue of their membership. Dr. Shelly Batra is a medical health professional and co-founder of the Appellant Society. White communication dated 19 June 2020, Mr. Sandeep Ahuja, who is also co-founder and CEO of Appellant Society, terminated services and employment of Respondent 1. The communication alleged termination of Respondent 1 on account of various omissions, including misrepresentation of daughter's previous employment, fabrication of documents, misappropriation of assets and funds of NGO, as well as gross misbehavior with staff and employees. Subsequently, on 23rd June, Board of Appellant Society said to have passed resolution terminating Respondent 1 from post or office of President of Appellant Society. Soon thereafter, on 27 June, Board or Appellant Society also said to have removed respondent from capacity as member of their board. Court concluded that a suit under Section 92 of Civil Procedure Code is a representative suit of special nature, since the action is instituted on behalf of public beneficiaries and in public interest. Obtaining a grant of leave from the court before suit can be proceeded with acts as a procedural and legislative safeguard to prevent public trust from being subjected to undue harassment through frivolous suits being filed against them, and also to obviate situations that would cause further wastage of resources which can otherwise be put towards public charitable or religious ends. However, at stage of grant of leave, court neither adjudicates upon merit of dispute nor confers any substantive rights upon parties. Several decisions of the court have outlined certain conditions or essential prerequisites that need to be fulfilled for suit to be maintainable under this provision. Court in Ashok Kumar Gupta's case delineated them as follows. The trust in question must be created for public purposes of charitable or religious nature. There must exist breach of trust or a direction of court must be necessary for administration of the trust. Relief claimed must be one or other of reliefs as enumerated under section 92(1) of the Civil Procedure Code. In order to successfully establish that suit is not maintainable under section 92, it would be sufficient to prove that one any of the conditions enumerated above has not been met. However, to assert its maintainability, all aforesaid conditions need to be satisfied. Trust can be said to have been created for a public purpose when beneficiaries are general public who are incapable of exact ascertainment. Even if beneficiaries are not necessarily the public at large, they must at least be classified section of it and not a pre-ascertained group of specific individuals. A crucial condition that needs satisfaction is whether institution or organization in relation to which certain reliefs are sought can in fact be considered to be a trust or a constructive trust. When no formal recognition has been given to institution, creation of a public trust can be inferred from relevant circumstances surrounding coming into existence of and functioning of institution or entity in question. Although it is not possible to provide exhaustive list of the same, yet they may include method of devolution of property to institution or its acquisition and circumstances, along with intention behind grant of property, that is, whether it was for benefit of organization or public beneficiaries or for personal benefit of any particular individual or family. Whether grant is accompanied with any fetter or obligation or qualified with condition expressed or implied regarding its use by grantee. Whether dedication was complete, that is, whether there was absolute cessation or complete relinquishment of ownership of property on part of grantor and subsequent vesting of property in another individual for said object, whether public user or unascertained class of individuals could exercise any right over organization and its properties, the manner of use of profits accrued, more particularly whether it's applied or reapplied towards benefit of organization and its objectives, etc. If aforementioned circumstances exist, an entity has been Registered as society under Societies Registration Act 1860, it would still be treated as public trust as per dictum of full bench of Kerala High Court in Keshav Panikar case, wherein it was observed that mere factum of registration of society under Societies Registration Act 1860 after it attained characteristics of public trust could not change character of properties which had already been constituted as trust properties. However, if institution has been registered from its inception as society under Society Registration Act 1860, it is true that whenever society acquires property, it cannot be said that it declares itself trustee in respect of said property. In other words, in effect of registration under Societies Registration Act 1860 would not to be automatically invest the properties of the society with the character of trust property. This has been consistently laid down by decisions of several high courts. Having said so, one must examine what effect the mechanism of vesting provided under Section 5 of Societies Registration Act 1860 has on society. It reads that the property, movable and immovable, belonging to society registered under the Act, if not vested in trustees, shall be deemed to be vested for the time being in governing body of such society. What follows is that property belonging to society can either be vested in trustees or in governing body of society. This vesting has been envisaged because a society registered under aforesaid act is not a juristic person or a body corporate capable of holding property by itself. The phrase, if not vested in trustees, must be read to mean that a trust can be created either expressly or impliedly before or after registration of society for purpose of holding its properties. A public trust would be created prior to registration of society if broad circumstances enumerated are met. In such a case, all property of the society which have been imbued with character of trust property would be subjected to section 92. However, if it is argued that trust has instead separately been created for holding property of society after its registration as society, same must be clearly and sufficiently proven. Here separate trust which has been created and properties which have been vested in said trust would be subject to scrutiny under section 92. In both these scenarios, express trust would be created and suit under section 92 CPC. The first criteria, the existence of express or constructive trust, would be met. In absence of such a separate vesting in trustees, the property belonging to society would be automatically vested through a deeming fiction in governing body of society. Such a governing body is duty bound to ensure that property is put towards and utilized for purposes or aims of society as laid out in its memorandum of association or any rules or regulations governing the said matter. In the event of society's dissolution, members would not derive any right to distribute assets belonging to society between themselves. Both during subsistence and dissolution of society, members or governing body cannot be said to possess any beneficial or individual interest or property vested to them. They would also safeguard society's property for future members of society or future governing bodies such that perpetuity is assigned to both society and its property unless expressly dissolved. All these factors evidence that governing body must also act within contours of a strict fiduciary relationship. Legislative creativity was employed to ensure that incapability of society to hold property by itself does not have practical effect on ability to use and administer those properties, while also ensuring that property of society must not be squandered or the object and purpose for which society was formed may not be defeated by persons having control over the properties. Therefore, Section 5 can be seen as providing two options or mechanisms through which society can hold the property belonging to itself, one in trustees or two in the governing body of the society. Both these mechanisms or options belonging to the same genus, fiduciaries, albeit they don't fall in the same species. The former is a trustee structure sensu and latter is not. Therefore, while society cannot be considered as express trust, what must also be noted at this crucial junction is that for an entity to be brought within the rigors of Section 92, plaintiff has option of also contending that a constructive trust exists in circumstances and breach of such a constructive trust has occurred, or that directions of court are necessary for administration of such a constructive trust. A constructive trust arises by operation of law without regard to or irrespective of intention of parties to create a trust. It is imposed predominantly because persons holding the title to the property would profit by a wrong or would be unjustly enriched if they were permitted to keep the property. American and English models of constructive trust also, although similar in nomenclature, bear a doctrinal difference. Former is remedial, while later is institutional. In other words, in implying existence of constructive trust, English courts recognize or give legal efficacy to fiduciary or confidential relationship or institution that already exists. It would arise by operation of law, but when one person is under existent obligation, existence from the date of circumstances which give rise to it, and function of court would only be to declare that such a trust has arisen in the past. What must also be noted is that for this equitable doctrine to be applied, fiduciary must receive property or money which he cannot consciously retain. It is only thereafter a constructive trust would be raised in favor of beneficiaries on whose account money was originally received. The factum that fiduciary withheld the property from its rightful beneficiaries must be established. That such a fiduciary sought to misapply property in contravention to covenants that bound him or sought to gain advantage for himself must be proved for a constructive trust to come into existence by operation of law. That he further divested the said siphoned property or funds would have to be proved to assert the constructive trust has additionally been breached. Even in absence of such divestment, directions of court may be necessary for administration of the constructive trust. Respondent, having made several allegations of siphoning of funds by respondent 3 and 4 for own personal use, could be said to have prima facie satisfied condition required to apply doctrine of constructive trust to present facts. Not to mention if allegations are found to have no substance, entire suit would fail. But in peculiar circumstances in which the present matter rests, that would happen also for the reason that circumstances which required imposition of constructive trust do not exist have been proven. However, if found true, all property diverted for purpose of obtaining pecuniary advantage would be subject to constructive trust, the administration of which can be sought in a suit under section 92 of CPC, and respondent 3 and 4 would be considered as constructive trustees. The phrase person having an interest in trust must neither be construed narrowly nor widely. It must be narrow for the reason that words used is interest instead of direct interest. However, it must also be remembered that while no direct interest is required, interest must denote present and substantial interest and not sentimental, fictitious, or purely illusory interest. While scrutinizing whether respondents are persons interested in trust and whether they bring the suit representative capacity, it is not their designation position which must be looked into or given importance to. While recognizing they have also sought some remedies related to personal grievances and wrongful dismissal of respondent 1, which could be seen as unduly magnifying an election dispute, there are several other allegations which cannot be ignored and which respondent 1 and 2 in a dual role or capacity which they are agitating matter under section 92 of CPC. Larger background in which suit is brought alludes to existence of public interest also at play. Reliefs claimed by plaintiff must fall within those reliefs outlined under section 92(1). As regard question when relief can be considered to fall under residual clause H, providing for further or other relief under section 92(1), the court in Charan Singh case elaborated that if relief prayed for is not a further relief but other relief which is not consequential to or in addition of certain other reliefs already mentioned in clauses A to G, then other relief must be akin to same nature as of reliefs in clause A to G. Furthermore, special nature of suit under section 92 requires it to be fundamentally filed on behalf of public or vindication of public rights. Courts must go beyond reliefs and also give due regard to object and purpose for which suit is brought. True nature of suit must be determined on comprehensive understanding of facts, and a hard and fast rule cannot be made for the same. The fact that certain private rights are being agitated must not be reason to ignore other allegations in suit and dismiss it outrightly, provided suit is instituted in a representative capacity. The reliefs in present plaint, as they agitate private rights, cannot be granted under a suit of this nature. It is clarified that issues involving day to day management of institutions and grievances by members qua other members as regard of election of members or certain board decisions regarding reshuffling of elected members must not be made suit of this nature, especially when grievances can be redressed through other mechanisms under regular suit not falling within 92 section. Such issues must not be deviously magnified or amplified. The reliefs like removal of respondent 1 from post of president and board member are concerned along with grievances may have with other board members would have been agitated in a separate suit, not being under section 92 of CPC. Court also clarified that issues involving day-to-day management of institution and grievances as regard members and election of board members and decisions pertaining to reshuffling of board members must not be made in a suit of this nature, especially when grievances can be redressed through other mechanisms or under a regular suit. Such issues must not be amplified as there is a breach of trust warranting intervention under this provision. Therefore, reliefs as far as removal of the respondent from president and board member are concerned, along with grievances with other board members, would have to be agitated in a separate suit and not under this.